Is larceny from a house a felony or a misdemeanor in Tahlequah? Many individuals facing criminal charges want to know whether larceny from a house is a misdemeanor or a felony. The answer is straightforward. Larceny from a house is generally prosecuted as a felony offense under Oklahoma law. A felony conviction can result in substantial prison time, significant fines, a permanent criminal record, and lasting consequences that affect employment, housing, and professional opportunities. What is larceny from a house? Larceny is the wrongful taking and carrying away of another person's property with the intent to permanently deprive the owner of that property. Oklahoma law treats thefts occurring within a residence more severely than many other forms of theft because of the heightened privacy and security interests associated with a person's home. The offense may involve the theft of money, jewelry, firearms, electronics, tools, collectibles, or virtually any item of personal property located within a residence. Importantly, a person can be charged with larceny from a house even if no forced entry occurred. The focus of the offense is the unlawful taking of property from the dwelling. Is larceny from a house a felony? Under Oklahoma law, larceny from a house is generally classified as a felony offense. Unlike many theft crimes where the value of the property determines whether the offense is a misdemeanor or felony, larceny from a house is treated as a felony because of where the property was taken. A conviction may expose a defendant to imprisonment in the custody of the Oklahoma Department of Corrections, fines, court costs, restitution, and other penalties imposed by the court. How is larceny from a house different from burglary? Many people confuse larceny from a house with burglary. Burglary generally involves unlawfully entering a structure with the intent to commit a crime inside. Larceny from a house focuses on the actual theft of property from the residence. Depending on the facts, prosecutors may charge both offenses arising from the same incident. In some cases, a person may be charged with burglary even if nothing was ultimately stolen. In other cases, an individual may face larceny charges without allegations of forced entry. Common defenses to larceny from a house charges. Every criminal case is unique, but defenses may include mistaken identity, lack of intent to permanently deprive the owner of the property, ownership or claim of right to the property, insufficient evidence connecting the accused to the theft, constitutional violations during the investigation, or false accusations by witnesses or family members. The availability of a particular defense depends on the specific facts and evidence in the case. What happens after an arrest in Cherokee County? Individuals facing charges will typically be required to appear before the Cherokee County District Court. The prosecution must prove each element of the offense beyond a reasonable doubt. Early intervention by an experienced criminal defense attorney may help preserve evidence, identify weaknesses in the state's case, negotiate favorable resolutions, or prepare a defense for trial if necessary. Speak with a Tahlequah criminal defense attorney. A charge of larceny from a house should never be taken lightly. Because the offense is generally prosecuted as a felony in Oklahoma, a conviction can carry significant penalties and long-term consequences. If you have been arrested or charged in Tahlequah or elsewhere in Cherokee County, get a free consultation with a criminal defense attorney at Kania Law, Tahlequah Lawyers by calling 539-867-2321.